Feinstein puts out a wildly inaccurate tweet to thwart Kavanaugh's confirmation. Are we surprised? No. By Amy Moreno for truthfeednews.com. Senator Dianne Feinstein is tweeting out misleading information on Judge Kavanaugh in an attempt to try and derail his nomination. Basically, Feinstein is claiming that Kavanaugh was nominated because he does not believe in prosecuting sitting presidents. The irony in all of this is that Kavanaugh was actually citing Bill Clinton's lawsuit from Paula Jones, where he ended up paying $850,000 to her for his sexual abuse and attacks. Daily Wire. On Friday, Senator Dianne Feinstein sent out the following tweet about President Trump's SCOTUS nominee, Brett Kavanaugh. The president's Supreme Court nominee has said sitting presidents can not be prosecuted, should not be investigated, and should have the authority to fire a special counsel at will. With the president facing serious legal jeopardy, the nomination should not be moving forward. So in other words, she's admitting to their plan without a crime being stated, given as fact, without a crime. You're guilty without the crime being committed. Then you have to prove your innocence. So she's admitting that the Democrats are out to get President Trump out. You see, that's why Mueller's investigation is still going on. So that's why, with Kavanaugh being in the Supreme Court, definitely you cannot oust, because he's a Republican, oust President Trump. That is their whole intention of this Supreme Court nomination. Feinstein's first contention that Kavanaugh has said that sitting presidents cannot be prosecuted and should not be investigated is wildly misleading. In 2009, Kavanaugh penned a piece for the Minnesota Law Review in which he stated, speaking first about former President Clinton. To be sure, one can correctly say that President Clinton brought that ordeal on himself by his answers during the deposition in the Jones case, if nothing else. And my point here is not to say that the relevant actors, the Supreme Court in Jones, Judge Susan Weber Wright and independent counsel Kenneth Starr, did anything other than their proper duty under the law as it then existed. But the law as it existed was itself the problem, particularly the extent to which it allowed civil suits against presidents to proceed while the president is in office. With that in mind, it would be appropriate for Congress to enact a statute providing that any personal civil suits against presidents, like certain members of the military, be deferred while the president is in office. The result the Supreme Court reached in Clinton versus Jones, that presidents are not constitutionally entitled to deferral of lawsuits, may well have been entirely correct. That is beyond the scope of this inquiry, but the court in Jones stated that Congress is free to provide a temporary deferral of civil suits while the president is in office. Congress may be wise to do so, just as it has done for certain members of the military. Deferral would allow the president to focus on the vital duties he was elected to perform. Congress should consider doing the same, moreover, with respect to criminal investigations and prosecutions of the president. In particular, Congress might consider a law exempting a president while in office for criminal prosecution and investigation, including from questioning by criminal prosecutors or defense counsel. Criminal investigations targeted at or revolving around a president are inevitably politicized by both their supporters and critics. As I have written before, no attorney general or special counsel will have the necessary credibility to avoid the inevitable charges that he is politically motivated, whether in favor of the president or against him, depending on the individual leading the investigation and its results. The indictment and trial of a sitting president, moreover, would cripple the federal government, rendering it unable to function with credibility in either the international or domestic arena, such an outcome would ill serve the public interest, especially in times of financial or national security crisis. One might raise at least two important critiques of these ideas. The first is that no one is above the law in our system of government. I strongly agree with that principle, but it is not ultimately a persuasive criticism of these suggestions. The point is not to put the president above the law or to eliminate checks on the president, but simply to defer litigation and investigation until the president is out of office. A second possible concern is that the country needs a check against a bad behaving or law-breaking president. I would say bad behaving or law-breaking president, but the Constitution already provides that check. If the president does something dastardly, the impeachment process is available. No single prosecutor, judge, or jury should be able to accomplish what the Constitution assigns to the Congress. Moreover, an impeached and removed president is still subject to criminal prosecution afterwards. In short, the Constitution establishes a clear mechanism to deter executive malfeasance. We should not burden a sitting president with civil suits, criminal investigations, or criminal prosecutions. In other words, he's saying that people could, like Mueller here, it's this investigation is because they can't stand Trump. That's why he's saying delay everything till after, unless it's something dastardly, like Hillary Clinton selling the uranium. I would say that's dastardly, but let's move on. It must be noted that Kavanaugh is not advocating that the Supreme Court do anything. He is stating that it would be appropriate for Congress to enact legislation which would defer criminal and civil suits until after the president leaves office. Moreover, he states that the Constitution already establishes a clear mechanism to deter executive malfeasance. This process is called impeachment. The power to bring impeachment charges against the president is expressly assigned to the House of Representatives in Article 1, Section 2, Clause 5 of the United States Constitution. The power to convict on those charges is expressly assigned to the Senate in Article 1, Section 3, Clause 6. Article 1, Section 3, Clause 7 then states, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. During a 1998 panel regarding the independent counsel statute, which expired in 1999, Kavanaugh stated a similar position. I think that last comment raises the question whether the president is subject to criminal indictment at all, which is a question that has been a lurking constitutional issue for a long time, which at some point here should be resolved so that we can determine whether the Congress or an independent counsel should investigate the president when his conduct is at issue. I tend to think it has to be the Congress because of that kind of attacks that we've seen recently and because of the types of issues that were just pointed out. It is war, and if it's going to be war, it's going to be Congress and not an isolated prosecutor appointed by a panel of 3 judges we've never heard of. When asked by a moderator, Mark Toohey, what the implication was if a sitting president cannot be indicted during a term of office, Kavanaugh replied, the implication is that Congress has to take responsibility for overseeing the conduct of the president in the first instance. That's the role I believe the framers envisioned, and that's the role that makes sense if you just look at the last 20 years. It makes no sense at all to have an independent counsel looking at the conduct of the president. Now, to be sure, most criminal investigations are going to involve multiple subjects, so we still need a criminal investigation ongoing. But when it comes to looking at the conduct of the president, it has to be the Congress. Congress has to get in this game and stop sitting on the sidelines. Even as Politico noted, an October 2000 opinion from the Department of Justice reaffirmed a previous opinion from decades prior that a sitting president cannot be indicted. In 1973, the Department of Justice concluded that the indictment and criminal prosecution of a sitting president would unduly interfere with the ability of the executive branch to perform its constitutionally assigned duties and would thus violate the constitutional separation of powers. No court has addressed this question directly, but the judicial precedents that bear on the continuing validity of our constitutional analysis are consistent with both the analytic approach taken and the conclusions reached. Our view remains that a sitting president is constitutionally immune from indictment and criminal prosecution. Feinstein's claim, here we go, that Kavanaugh believes that a president should have the authority to fire a special counsel at will is once again misleading. I highly doubt it. The Constitution states it very clearly, Mrs. Dianne Feinstein, with your Chinese spy for 20 years. Let's start looking at you. Maybe that's why you want Trump impeached. In a 1998 article for Georgetown Law Journal, Kavanaugh wrote that Congress should give back to the president the full power to act when he believes that a particular independent counsel is out to get him, just like Robert Mueller. Yet Trump lets it go. Let's see. Currently, an independent counsel can be removed for good cause. A term undefined is a matter of law or practice. A special attorney appointed directly by the Attorney General can be removed at will. The good cause quote, provision strikes many commentators as unconstitutional or at least unwise, as Justice Scalia intimated in Morrison. At first blush, it is somewhat difficult to understand why the president does not have the authority to dismiss any executive branch official at will. In any event, Justice Scalia also argued that a federal prosecutor should be removable at will for more practical reasons. That the primary check against prosecutorial abuse is a political one, and that the independent counsel system thwarts this traditional check on a prosecutor's actions. If there is an out-of-control prosecutor, Justice Scalia's reason that the president should possess the authority and responsibility to remedy the situation. Congress should give back to the president the full power to act when he believes that a particular independent counsel is out to get him. Such a step not only would make the special counsel accountable, but it would also force the president and his surrogates to put up or shut up. The objection to removal at will is that the independent counsel might be too timid because of fear that he could be fired. The objection overstates the danger. After all, a number of special prosecutors have been appointed throughout our history, and there is simply no persuasive evidence that the threat of removal adversely affected their investigation. Indeed, in a perverse way, removal is a sure way to immorality, as Archibald Cox learned. Moreover, President Nixon's firing of Cox, the last occasion when a president removed a special counsel, created an enormous controversy and triggered impeachment proceedings. History clearly demonstrates that the president will pay an enormous political price if he doesn't have a persuasive justification for dismissing a special counsel. The deterrent to a president dismissing a special counsel thus would be the same as the deterrent to his firing the Attorney General, a practical and political, as opposed to legal deterrent requiring the president to be able to explain his decision to Congress and the public. Even Supreme Court Justice Elena Kagan has praised Scalia's dissent in the Morrison case, which Kavanaugh cites in his Georgetown Law Journal article. Intentionally or unintentionally, Senator Feinstein has greatly misinformed her audience by whittling Kavanaugh's lengthy and nuanced opinions down to a 140-character panic tweet. Kavanaugh's views regarding the indictment and prosecution of a sitting president appear to be the norm, reflected by the Department of Justice twice over. His opinion on presidential power over special counsel investigators also appears balanced and well thought out. Perhaps the most important part of Kavanaugh's opinions regarding these issues is that he continually places the onus on Congress to act rather than an activist Supreme Court. However, this doesn't seem to matter much to Feinstein. Expect more of this from the Democrats as confirmation time approaches. Look, it's so obvious. You know, I would say to exactly what it was stated. Put up or shut up. We let Mueller go on continuously. Put up or shut up, and let's start investigating the real criminals. Let's start investigating Dianne Feinstein for her 20 years hiring a Chinese spy, okay, for 20 years. Let's start investigating that scenario. We're not just going to go along, oh, I didn't know, and once I knew, I fired him. Let's not go with that. Dianne Feinstein is part of the corrupt deep state, and she's been in there too long, and it's time to clean this crap out. Let me know what you guys think in the comments below. And again, thank you so much for watching.